Good evening, friends. I've been advertised for a politico-legal topic to speak on something which has a much broader appeal, supposedly. I'm very doubtful about lectures, though, this kind of format, whether it encourages lectures. But since that is what I've been asked to address you for about just under half an hour, till you get Justice Suryakant, let me attempt to keep your interest. Friends, India at 75 and separately the Indian Supreme Court at 75 are obviously heavily intertwined. They are like scrambled eggs. You cannot look at one without the other. But let me start this with what might seem like a simplistic question. And I've done it for years now, for Indian audiences, for foreign audiences. I just completed at the end of October a very, very interesting, productive, but a very tiring whirlwind US universities tour for about week 8 days from Harvard to New York University to Columbia to Berkeley to California, Los Angeles, etc. And I started with many foreign audiences with the same question which I am now asking you. Ask yourself, why is it that in the 30s to the 60s, from the 1930s to the 60s, where approximately 30 to 40 countries emerged as young independent nations from the yoke of imperialism across the length and breadth of Asia, Australasia, Africa, South America. They emerged from the yoke of British imperialism, Dutch, French imperialism, Spanish imperialism, and so on and so forth. Ask yourself why it is that India and India alone, and that's quite a fantastic achievement, India and India alone remains a vibrant democracy 75 years later down the line. Not one of the others across the length and breadth of these continents. You will find the wrecks and ruins of constitutionalism littering the constitutional landscape in these areas. But India continues with resilience and vibrancy to be the only democracy. The question is why? And my first answer, as always, is I don't know the answer. I really genuinely don't. It's a matter of great research, I think. Second answer is sheer good luck. Third answer is God's will. When I am forced to give more logical answers, or at least more reasoned answers, then a possible answer could be that we got the sequencing right. We got a Gandhi and then a Nehru. I'm not sure if the result would have been the same happy one had it been the other way around. There is no more remarkable agitational politician, possibly in the history of mankind, but certainly in the last 300-400 years. There could be no better agitational politician than Gandhi, who could get us independence, and of course, remarkably, in a non-violent movement. But after Gandhi, at independence, you also had a Nehru. Of course, a very favorite whipping boy nowadays. But you needed the magnanimity of Nehru. You needed a person with a genuine commitment and belief in democracy, a belief in Voltaire's famous words, which exemplify the essence of democracy, namely that I will differ with you completely, but I will defend to death your right to differ with me. Nehru was that, with his slightly left of center, Fabian socialist, over-romantic views about governance, but certainly a person who believed in democracy. Our neighbors, good, bad or indifferent, didn't have the same good luck. Our immediate neighbors did not. Consider how this Jugalbandi, this perfect mix of the secret sauce, Gandhi and then Nehru. Consider what might have happened if it was Nehru and then Gandhi. I don't think Nehru could have alone or in any manner himself, without Gandhi, got us independence. And Gandhi, with all his remarkable moral compass, his inflexibility, his commitment to principles, his view that ends come after means. Could he have made a governance prime minister? It's a tantalizing question and a question up for research. I have given you what I think are my answers. Of course, these require very solid quantitative research to validate, or for that matter, for invalidate. I next turn to the pillars of this Indian democracy, which emerged from the yoke of imperialism and remained the shining exception across the wrecks and ruins of constitutionalism in Australasia, in Africa, in South America. Clearly, the first pillar is the much abused secularism. And I must say at the outset that, I'm going to give this very wide topic about India at 75 and the Indian Supreme Court at 75 in less than 25 to 30 minutes. So you will pardon me if I claim the Nobel Prize for miniaturization, or for that matter, the role of a fan dancer who doesn't attempt to cover anything. But secularism is clearly the first of those pillars of Indian democracy. Howsoever abused, howsoever maligned, howsoever villainous a word, this is a word which of course must be seen along with that other great word of our constitution, which of course this other great word, fraternity, was in our preamble. Secularism came later. Both of them in a nutshell have to signify inclusiveness, pluralism in planet Earth's most diverse spot. There is no more diverse spot on planet Earth than India. The Americans, whom I just spoke to a few months ago, like to call themselves a salad bowl or a melting pot. They have to rethink the definition of those words when they see the diversities of India. The largest number of languages, hundreds and thousands of dialects, the birthplace of 4 religions, the second, third or fourth largest populations of 3 more, smells, sounds, rituals, dresses, everything bewilderingly diverse. Into this, fraternity and secularism signify inclusiveness and pluralism. Let me dig a little deeper. What should it mean? It really means, I think the best definition I've come across is Professor Rajiv Bhargav's, ex-Harvard Law School's definition. He said, Lincoln coined this great phrase for democracy: of the people, for the people, by the people. So he said, I can understand by the people. He said, I can understand for the people. But why did Lincoln say of the people? That's a strange phrase to use. And then he answers it by saying, of the people is supposed to signify a co-ownership of democracy. And unless you can convey that sense of co-ownership of democracy to each person, to the last man in the last row or to the last woman in the last line, you will not have true secularism or a fraternal spirit. The third pillar of this very precious and special democracy, the world's largest, is federalism. An amazing word, because if you Google the Indian Constitution, one of the largest in the world, you will find no word federalism. You will find the word federal several times, but that's the federal court, the precursor of the Supreme Court. There is no word federalism in the entire one of the longest constitutions of the world. And yet, it has been held to be part of the basic structure of the Indian Constitution. It's been held because it manages diversities. So it all comes back to the same thing. As somebody put it, it manages the 3 Ds. The 3 Ds being dissent, discomfort, and dissatisfaction. It acts like a pressure valve. It allows local, decentralized, diffused explosions to take place at state and below state decentralized levels to prevent big explosions at the center. So federalism is another name for managing diversities. This is not the time and not the place, and certainly it requires a separate lecture by itself, which I have done on federalism, to tell the unusual story that while India was created largely as a unitary country or a unitary constitution, because our framers were scared by the fissiparous breakaway tendencies of partition. They were scared for the integrity and security of India, because we followed the British model. So we created in text and in model and in design a largely unitary constitution. The amazing story, for which I don't have time now, is the story of how accidental federalism or unintended federalism or inadvertent federalism has made India today, 75 years down the line, actually a much, much, much more federal country than our framers designed in text. It has been possible because of federating influences at every level. Linguistic federalism, the three-language formula, the check-in and the reining in of 356, which is been seen as the biggest enemy of federalism. Fiscal federalism, whereby we now devolve roughly and approximately 45% of all central funds to state entities. Around independence, that was 30%. Grants or funds or taxes go back to the states to the extent of about 45%, actually 43 or 44, soon to reach 45%. That's fiscal federalism for you. And so on and so forth. Decentralization, the entire Panchayati Raj movement, that is federalism for you below the state level, the three-tiered system. Today, 90% times as a member of parliament, if I go for any welfare project to inaugurate or to initiate or to propose, 90% plus times I am faced on the other side of the table with a woman who is the elected head, either of the panchayat or of the intermediate level or of the state level. You have 1.5 million women elected. Unimaginable. This is true federalism in operation. So that's the third vital pillar of Indian democracy. The fourth is, of course, parliamentary democracy. We are not a democracy alone, we are a parliamentary democracy. And parliament, of course, is not merely a phrase to call it the temple of democracy. It has to be kept like that in operational reality. I have always spoken and written about what I call central hall culture. Central hall is not a building, it's not a room, it's not a space, it's a concept, it's a culture. Apart from being the world's best and biggest gossip spot, it is also a place where true democracy breeds, because people across the political spectrum with totally divergent views are able to sit and talk and exchange without fear of favor and without fear of being misreported. And that, I think, is not what the two ladies in Bangladesh can do in their central hall. It is not what Nawaz Sharif and Musharraf could do in Pakistan, or for that matter, any of our neighboring countries. And that spirit, that magnanimity, that special relationship across the lines is something to be cherished. I feel sad that many of these values I'm talking about are diminishing, are going down. Divisiveness or expulsions should not be the calling card of parliamentary democracy. I only hope and trust that people realize the importance of parliamentary democracy, the give and take in it, and rescue it before that culture diminishing to vanishing point. Apart from these non-institutional, there are these institutional pillars of Indian democracy. Parliament is one, but equally there are the CAG, the Election Commission, the Army, and in many ways, above all, the Fourth Estate, your tribe. Each has its great failings, each has its great diminishing shortcomings, but each is undoubtedly a pillar of Indian democracy. You need therefore to protect its essence. For example, take the army. Without sounding sexist or chauvinist, I'm reminded of that saying that the army should be like that Parda Nashin lady who is the anchor of the house or the anchor of the home in many families. Maybe not much heard or seen, but she's the rock support behind which the whole thing functions. We don't think we should not be able to think of the army, but it should be there for us in the backdrop. These are principles which warn you against politicization of these institutions, be it the EC, be it the CAG. And above all, the third organ of state, the judiciary, which of course links with the Indian Supreme Court at 75 as well. You can like the judiciary, you can hate it, you can criticize it, you can applaud it, but you cannot take away from the fact that the highest trust quotient, the lowest trust deficit amongst all the non-institutional and institutional pillars of Indian democracy remains in this organ. There must be some reason for it. It is also something to be remembered that we have this combination of the most avant-garde doctrines, the best and the brightest in terms of on the bench and in the bar, inhabit this judicial system in India. I can tell you, having dealt with them across the world, the best and the brightest are in our system. We have avant-garde doctrines like PIL, like basic structure. Imagine a doctrine which in one sentence says, a constitutional amendment can itself be unconstitutional. Imagine the depth and the width of that doctrine. We have judicial review of a magnitude which would make Marbury and Madison, the original Supreme Court US judgment, blush. No other country on planet Earth has anywhere near the all-encompassing and invasive judicial review which Indian courts can and do frequently exercise. Now, before I come to the judiciary for the remaining few moments, let me underline 5 features, critical features of Indian democracy. One, that it became a constitutional democracy in 1947, basically on a remarkable mix and faith of the founders in nationalism, but along with nationalism, with the aim and the goal to foster a social revolution. These two were the defining approaches, and a remarkable human being, a triple intersection of an American who studied at Oxford and read and studied only Indian history, modern Indian history, Granville Austin, has summarized that remarkable moment in our constitutional assembly which led to the birth of constitutional democracy in 1947. The second critical feature is how we institutionalized in democracy an enlightened citizenry, giving them one person, one vote. It's something so normal, so obvious, so small to say that there is one person, one vote. But imagine in a country with this degree of poverty and illiteracy, imagine that even USA, women got the vote not so long ago, less than 100 years ago. In that country, for the founding fathers to make it an article of faith, and then to grow from the elections of 1951 and 52, which had around 80 million people voting, to choose 489 members of parliament from amongst 1849 candidates standing. From that, to go in the last election of 2019 to 900 million people being eligible to and voting, for 8,000 candidates to elect 543 MPs. That's no mean achievement. And of course, to go from there to ballot papers, to electronic voting machines, and so on and so forth. So this festival of democracy in which we participate is not something to be taken for granted. The third critical feature of Indian democracy is how the Constitution of India laid the foundations for the rule of law. It is not that our signatures on the covenants of human rights, civil and political rights, which India went into in the 70s, not our commitments to the Universal Declaration of Human Rights in the United Nations, but ultimately these impulses are found in every part of our Constitution, which show a complex interplay between two seemingly contradictory portions. that of ensuring fundamental rights and that of ensuring social economic justice through the Directive Principles. The design is itself very interesting, a right followed then by detailed reasonable restrictions with, as far as possible, the basis of the restriction stated. It is unlike other constitutions. It is not found in the US Constitution, one of the oldest. It is not found in many other written constitutions, this kind of a structure and nuance. 5 facets of the Supreme Court, which is of course the fourth aspect of this democratic structure, the third pillar of democracy, the third organ of state. These 5 facets of the Supreme Court over the last 75 years must also be remembered and constantly reminded and reimagined to ourselves. The first is that the structure of our apex court is that not only of a constitutional court, which it undoubtedly is, but also as an appellate court. So you have in these 75 years the Supreme Court dealing with pedestrian topics from tenancy to land acquisitions, along with that to complicated abstract questions of constitutional law, where the heights of jurisprudence and abstraction are attained. Perhaps the court remains the most trusted organ for the citizenry because it continues to deal with so many matters which touch the ordinary lives of ordinary citizens and does not remain a far removed constitutional abstraction alone. And it is for that reason that I am not always supportive of this move to make the Supreme Court into a pure constitutional court and to take away its more supposedly pedestrian jurisdiction. The second facet of the Supreme Court has been as a positivistic court. A positivistic court during a certain phase of its growth and evolution. A positivistic court when it was more deferential to the executive and the legislature than was necessary, where its timidity led to a reluctance to assert powers which it already had beyond any other apex court in the world. It was not only the emergency, but other periods also when this more deferential approach led to judgments which are best forgotten. Of course, ADM Jabalpur was the Indian moment of Liversidge and Anderson in the UK in the Second World War. It was the Indian counterpart of Dred Scott when the US Supreme Court upheld slavery as constitutionally valid. The third facet of the Supreme Court was its post-emergency quest for legitimation. Whether it had to seek legitimation in its own eyes and in that of the country, or because it happened in a natural way, it is clear that from the 80s, this post-emergency quest for legitimation by the Supreme Court led to an exploding judicial review. Judicial review beyond imagination, beyond bounds, beyond limits, and has made the court now for more than 4 decades. A large chunk of time of my life has been spent in this court, has made this court over more than 4 decades by far the most activist, I would say 5 decades actually, 5 decades, most activist, most highly judicially reviewing court. The fourth facet of this growth, of the growth of this institution, is as a democratic institution focusing and promoting the virtues of equality, of transparency and social justice. You see that every day in the various matters it deals with, from gender issues to governance issues to RTI issues as far as transparency is concerned, and of course to socially divisive issues about classes and the dialectics of class struggles, from backward classes through Indira Sahni's judgment to gender equality issues to the anti-sexual harassment guidelines of Vishaka. So this was a phase of the Supreme Court with as a liberal democratic institution focusing on equality, transparency, and social justice. And then is the contemporary phase, where under the leadership of the 50th Chief Justice of India, you have this liberal institution going in that journey, zealously guarding its turf, trying to speak, perhaps not enough times, trying to speak truth to power, dealing with fundamental issues of judicial independence, appointments, delays and refusals by the executive, and free speech and expression issues. So the last two phases have been its quest for entrenching its identity in the country's memory, institutional memory, as a liberal institution. As I draw to a close, I'd be feeling it my duty if I did not highlight 3 out of many, many more scourges of the Indian legal system, or drawbacks, or inhibitions. But the word scourge is most appropriately applicable to the backlog, or how to beat the backlog or arrears problem. We cannot hold our head high with the best and the brightest and doctrines like basic structure and PIL when we have an arrears pendency of 5 crore cases a few months ago. 5 crores. We cannot even face people when we hear of that figure, and mind you, people tend to forget that these are figures for the judicial institution, that is the Supreme Court, the various high courts, and the district judiciary. This figure ignores possibly 50 to 75% of a similar additional figure not counted here of the revenue courts, which are spread across the length and breadth of India. If you have an aggregation of 7.5 to 10 crore pendencies, then you have a broken system. This is not the place to discuss why, how, and how to solve the problem, but clearly you cannot have hospital equipment, hospital buildings with no doctors. You cannot treat patients without doctors. At any point of time in the 75-year journey of the Indian Supreme Court, and this is quite a remarkable statistic, at any point of time, 1/3 of all high courts spots has been vacant. Can you imagine a country of over 1.25 billion served by only 1100 odd high court judges, and at no point of time from independence till today, 75 years later, has more than 66 odd % of those 1100 been filled? How do you expect arrears to vanish? Similarly, in the district judiciary, the 25,000 odd district courts in the lowest tier of our system, at no point of time have more than 75% slots been filled. 1/4 have always been vacant. These are matters which don't require rocket science, but they require the elimination of politics. I always joke and say that any of you blindfolded persons who are not lawyers, if blindfolded and sent across the country to find the 10 best lawyers to be appointed to X High Court, Y High Court, A High Court, B High Court, C High Court, laymen like you blindfolded will be able to locate the 10 best lawyers to be elevated. The tragedy in India is that after we find them, instead of appointment, we do disappointment. We start doing the process of disappointment. That is why these arrears and these vacancies thrive. We do not experiment with any one new innovative system for long enough consistently for it to have effect. For example, we have a provision in our Constitution, 224A, which is more than about 62 years old. It allows the appointment of ad hoc judges. Ad hoc means to fill up the vacancies, 1/3 in the High Court at all times, by ad hoc appointments which don't need fresh selection. They can be retired judges who are already tried and tested, who don't want anything except to contribute to disposal. We have had hardly 5 or 6 such ad hoc appointments in 60 years since the article was put in our Constitution. And believe it, not one at the High Court level. This applies both to the High Court where we had 6 and to the both to the Supreme Court where we had 6 and to the High Courts where we had nil. We haven't, of course, now in 2023, I welcome very much the new mediation bill. But ultimately, this problem of clogged arteries of our system can have only a bypass operation. And the bypass operation has to happen by ADR, by alternative dispute resolution systems, of which now for the first time we have a shining new state-of-the-art modern comprehensive enactment in 2023 September called the Mediation Act. And I hope and trust that will declog these congested and clogged arteries. I hope and trust that we will start having quantitative assessment of new legislation which we tend to pass indiscriminately. We tend to pass legislation right, left and center as if passing of legislation will solve the problem. I've always called us a over-legislated, under-enforced country. But what is the effect of a particular legislation on arrears? We do not do a quantitative assessment. As you know, as a parliamentarian, when I get a new bill, I get a cost assessment in other ways, a financial memorandum, but I don't get a quantitative assessment. Just to leave this thought with a small example, the 3 new criminal law amendment bills which are yet to come to our house and were supposed to come to Lok Sabha yesterday, but for the unfortunate incident, and where I am advertised as the lead opening speaker in the Rajya Sabha. Forget the details, forget the debate on that, but by mild cosmetic changes to about 1,000 sections over 3 huge enactments. I'm now not talking of meaningful or substantive changes, mild cosmetic ones. Do you know the amount of extra litigation you will generate? The corpus of litigation, which is judgments which stand the test of time over 100 years on the IPC, CRPC or Evidence Act. They are a corpus of jurisprudence which are a guidance for every judge in the district court and the High Court to follow. Today, by tweaking the section slightly for whatever purpose and object, you are giving a license and a charter for an accused or the prosecution, depending on which case, which side you are on, to argue that all the 100 years of law is inapplicable and that the judge, faced with a new set of acts, must decide de novo. Did anybody think of that before passing or proposing these 3 laws? That is how we add to this scourge, this mountain, this mammoth of arrears, and ultimately leads to a broken system where an average litigant cannot face this mountain of 5 crore pending cases. The second issue which the judiciary needs to address are issues of integrity and ethics. There is no organ of state which is not subject to humongously more scrutiny, be it MPs, Parliament, average citizens, executive, ministers. Each is subject to far more scrutiny than judges are. They may like it or not, but I have no hesitation in saying that. Now, this does not mean that you must have external scrutiny, because you have to protect the independence of the judiciary as much as make it more accountable. The way out is for you, yourselves, to create a mechanism which evokes more faith, trust, which is sufficiently objective, external and transparent without involving outsiders. But it can't be the present in-house procedure, which is opaque. None of you know about it. None of us know about it. What happens once a complaint goes, how it is decided, dealt with. This must change, and you must change it yourself before others change it for you. It would be tragic if others attempt to change it for you. And therefore, I think this is an issue which, before much time is out, you must address yourself. I don't hesitate to say that while the judicial system can preach and can write judgments and can sermonize about transparency to every other organ, the form we fill every day as parliamentarians, how the press takes off the pants of people in public life if you do a small step wrong, none of those standards which you write about in your judgments, not a fraction of them apply to the judiciary. Of course, all of them can't apply, should not apply, because you must protect independence of judiciary. But there must be a way in which you can balance both these virtues, otherwise they will convert to vices. The other issue about the judiciary is about independence of the judiciary. Without an independent judiciary, we cannot be a democracy. We cherish it, we have grown up in it, and with all the vicissitudes, all the highs and lows of 75 years, we believe that you cannot have any other organ of this country independent if you do not have a judiciary which is independent. Because that is what protects liberty, that is what protects human rights. But there again, attacks on judicial independence are both covert and overt. And frequently the covert ones are much worse than the overt ones. Decrease in judicial independence is as much from within as without. You have to guard against all of these. And the only answer to that is outstanding quality at the source, good selections at the source. One single bad appointment has a cascading downwards effect, which is incurable. It is only followed by lamentations, pulling out your hair and giving sermons and lectures. It is much better to be safe than to be sorry. It is better to have vacancies, better to take your time in appointment, but make sure you appoint the right person at the right time. This links with what is considered the delay in appointment, which leads to this static figure of 1/3 vacancies at all times in all high courts put together, and 1/4 vacancies in all district courts and lower courts put together at any point of time in 75 years. After 3 7-judge judgments have said that a second reference leaves the government with no discretion. I repeat, no discretion. And these 3 7-judge judgments of the Supreme Court came more than 25 years ago or 22 years ago in the 90s. I wonder then how every day in the newspapers we lament that I proposed her name and it went up. It came back with one reference, and I again second time as a judge proposed her name, and it is now still languishing with the government. Why do you need to lament? Have you ever tried issuing one single contempt notice to a law secretary saying, this is a second referral back, how can you sit on it? There is absolutely no discretion. Nobody is saying that it's an enjoyable process to issue a contempt notice to a law secretary. But you have to set the system right. You cannot say that there are 5 crore cases pending in this country, and yet something like 300 out of 1100 high court slots are vacant because matters are pending before governments after they've passed the collegiums of the High Court, the collegiums of the Supreme Court, and the various other vetting processes. So, as I said, truth is always bitter, but I usually don't mind being unpopular. So, may I end, folks, with basically bringing you back to what I opened. If you find it quite remarkable and unprecedented that India remains the only country which 75 years ago, along with 30, 40 other countries, emerged from the yoke of imperialism and has been the only one remaining an independent, democratic, vibrant nation, then you have to ask yourselves what each one of you are doing to strengthen each one of these non-institutional pillars of Indian democracy which I have talked about, to reinforce each one of these institutional pillars of Indian democracy I have talked about, and to see that these drawbacks and disadvantages are reduced or minimized, not, of course, eliminated. Thank you very much indeed for a patient hearing.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.